Hey out there, legal warriors, how do you define a good result in a criminal case? That's a hard question. And it's one I've been talking about recently, even with my own associate attorneys. So if you're interested in the criminal law, if you have a crime you're dealing with, stay tuned. This is the video for you. My name is Attorney Lance Fryrear, and I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. How do you define a good or a great result in a criminal case? Because let's face it, there's a lot of possible things and outcomes that can happen in a criminal case. And when someone asks me, well, what's one of the benefits of being a criminal lawyer? Well, it could have always been worse, basically, the outcome, because the government has a lot of power. But also one of the difficult things in being a criminal lawyer is trying to define what a good outcome is for yourself and for the client, because, we're on the same team. And so there's different categories, I think, of cases where outcomes and getting out of the case in a good way that can look a little different. So the first rule that I tell my clients and that I tell my attorneys that work with me and for me is any outcome where the client can control the result, any offer where the client controls the outcome, basically, is generally a really good offer, a good way to resolve a case. And what do I mean by that? Well, for gross misdemeanors and misdemeanor crimes, sometimes you can get an offer out of a prosecutor where if the client does certain things, they get a certain result. And sometimes we call that a stipulated order of continuance, a contract between the government prosecuting authority and the defendant and defense attorney that, hey, if I stay out of trouble for a period of time, 12 months, 18 months, 24 months, don't have any crimes, and maybe I do some affirmative conditions, maybe it's a classes, alcohol treatment, something like that. If I get through that successfully, then the government has to dismiss the case. And while it would be nice to have them dismiss the case right away, if you get to control the outcome by your own behavior and by your own efforts, you've taken back power. You've taken power back from the situation, from the government that charged you with the crime. And let's face it, I don't want the 6 people who aren't smart enough to get out of jury duty to decide whether or not my client goes home at night. So if I can get an offer where the outcome is guaranteed by the behavior of my client, by your behavior, that's who I'm willing to bet on. And hopefully a client, a person charged with the crime, is willing to bet on themselves as well. So that is a really good outcome when we can get that type of offer. What type of cases might we be able to get that type of offer for? When I say we, I mean the defense bar. I don't mean my firm. I mean people, dealing with the situation. Well, non-felonies, number one, and usually not a DUI. Okay, charges that are assault, theft, hit and run, cases like that. Oftentimes you can negotiate something that could end up in a dismissal. On a DUI, oftentimes the reduction is a lesser charge, reckless driving or negligent driving first degree, sometimes and rarely a traffic infraction if there's really bad factual issues, and sometimes you can get a dismissal, but it wouldn't be a negotiated dismissal. That would have to be more likely at a motion. And while DUIs don't typically get reduced to dismissal level, is because there's professional witnesses in those cases, right? The government has more evidence. They have an officer who built the whole case. They're not relying on the witness who says that they were hit and it wasn't self-defense, or the unreliable witness who's not going to show up, or the disinterested witness, the security person at Nordstrom who doesn't want to come and testify on a theft, things like that. So a good outcome is something where you can control it and hopefully ends in a dismissal. What's another type of good outcome where you can control it? Well, is there something called a deferred sentence. A deferred sentence can be a really good outcome if you can't get an SOC out of it, but you enter a plea to something, but they defer the sentence, which means it's on your record for a period of time. Then after a period of time, if you stay out of trouble, they undo the guilty finding and they dismiss it. So it turns out a whole lot like an SOC, you just have a guilty finding for a while. So that can also be a very good outcome. And of course, a great outcome is a straight dismissal. How can you get straight dismissals in non-felony cases, well, there's something called compromise of a misdemeanor. We have a video of that here on our station. Certain cases where there's a victim that has a civil cause of action, you can settle that civil cause of action with them and then petition the court under a certain statute to ask the court to dismiss the case. Those often work for hit and run, for theft, sometimes for assault, malicious mischief, cases like that. Although they can't be on a domestic violence case, that's excluded from compromise of a misdemeanor. How else can you judge whether the result, a possible offer, is good or not? Well, you have to take a look at your record, right? The prosecutor is going to take into account your good record or your bad record when making an offer. When I say record, that means prior times you've been in court, prior times you've had criminal matters. The worse your record is, the more likely the prosecutor's going to want jail time, the more likely the court's going to want to give you jail time. And so if you have a really bad record and you're getting an offer that doesn't lead to a dismissal, but it keeps you out of jail, that might be a good offer. You also have to consider what's the strength of the case, right? Ask your attorney, is it very likely that the prosecutor would be successful in convicting me at trial, or is it unlikely, right? And listen to what they say. But it's not just are they likely to convict you, are they likely to go through that much trouble to take you to trial? What's their caseload look like, right? If you were to confirm it for trial, would the offer get better? That's something you have to consider in whether or not the outcome you're being proposed is a good outcome for you. So I've talked about non-felonies. Let's move up to felonies, okay? What's a felony? That's a serious crime that's punishable by more than a year in jail as a maximum. And think, serious injury assaults, sex offenses, serious property crimes or property destruction, arson, unlawful imprisonment, choking somebody, shooting somebody, stabbing somebody. These type of cases don't have the same outcomes generally available for negotiation. They're a lot more fact pattern driven. They're a lot more proof driven because prosecutors prosecuting that serious of a crime, they have to take those results more seriously because there's more people that have been victimized allegedly in some way. So in felony land, sometimes there are alternative programs, like almost like an adult diversion. In Snohomish County, it might be called TAP, Therapeutic Alternatives to Prosecution. There's drug court, where you could lead to a dismissal. There's parenting sentencing alternatives if you have children that can be affected by things. There are ways you can lead to a dismissal, which would be a really great outcome in felony court. But for the most part in felony court, if you can get an offer of a reduction to a gross misdemeanor, that's usually a great offer. If you can't get an offer to a reduction and you have a non-violent offense as defined by law, you could sometimes ask for a first-time offender waiver. A first-time offender waiver says I have no prior felonies. The felony I'm charged with is eligible for a first-time offender waiver. If that's granted, you ask for it from the court after a plea to something. If it's granted, the court's able to waive the standard range sentence, which is usually months or years in jail, and impose possibly no jail and treatment. It's usually, hey, I have some counseling to do, some alcohol counseling, mental health counseling, some drug therapy, something like that. That's something that we use quite often when the fact pattern won't allow a reduction off of a felony, and the fact pattern suggests we'd lose a trial, but there's some really good factors for the client that means they shouldn't have to go to jail because of their lack of history and all the good things they've done after the fact. So that would often be a good outcome. If you're facing a sex offense, a good outcome would be anything where you don't have to register. That would be a reduction to a charge that doesn't require registration, or something that's going to at least cut down on any type of incarceration. Also, for the people facing those serious crimes, sometimes there are special sentencing alternatives one can go for that can greatly reduce penalties, and so that's what you can look at to decide if you have a good outcome. And I think finally what you have to remember is collateral consequences. When wondering if the proposed outcome is a good outcome, you have to look at collateral consequences. Are you a non-citizen? Are there immigration issues? Do you travel so you're not going to be able to get into Canada if you're found guilty? What's going to be the effect on background checks, right? Are you going to be able to coach for your kid's soccer team now if you have a certain type of outcome? How long will the outcome take to achieve, and what are the other options. So the collateral consequences that you can face are pretty serious, and the more serious the collateral consequences you have, the more likely your attorney may be able to bring those to the prosecutor and point out, hey, we need a different type of outcome if we want to avoid a trial in this case because of the unique situation that the particular client, the particular defendant is in. So bottom line, everyone wants to get their case dismissed, and they can't all be dismissed. But if you get an offer where you can control the outcome so you can lead to a dismissal, it's generally something you want to do because the government is power, right? The government can put people in jail. They can incarcerate you. And even if you're innocent, you can still be found guilty because juries want to convict people. They just do, right? It's very hard for a jury to wrap their mind around beyond a reasonable doubt. And while we all want to think that we've got this great system that protects the wrongfully accused, I think we all know better than that. So I hope you found this useful. I'm really, striking up the symbols for if you get an offer where you can control the outcome, take it and run. And I want you to stay positive and take a look at everything you can do and ask your attorney, what can I do to help you get me the best result? So if you found this useful, please like and please subscribe. More people get the help they need. More importantly, if you have a criminal matter in Washington State and you need some help, feel free to give my office a call. We've been doing this for more than 20 years. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.